Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to be talking about basics of the Sunshine Act, or more commonly known as Pennsylvania's meeting law. Couple preliminaries before we jump into the topic. First, this session is based on PowerPoint, if you've never attended one of these before, and I'll be talking in the background. But if you're interested in having a copy of the PowerPoint presentation, you'll find that on our website under the training tab, and we include all of the PowerPoints for our webinars and other training activities. You're welcome to download any of those and have them available for reference for future use. Or maybe you have a colleague who wasn't able to attend today and it would prove helpful. Or if you're conducting some localized training, feel free to use our materials to help yourself out. Also, this session is being recorded, and the recordings typically end up being uploaded to YouTube and then linked again on our website. Go to the training tab, and I think you'll find a sub-tab for recordings, and this session will be up probably in a couple days, and the administrative staff is pretty quick with taking care of that. So again, you can link to it, use it for your own future reference or any localized training that you may have. As I said, I'll be narrating in the background. If you have questions, feel free to type them into the chat feature. And the way typically we work this is that I do my best to answer the questions live as we're going through the presentation. But I have, two conditions here, if you can indulge me. First is, we're talking about the Sunshine Act, so please do your best to keep your questions on topic. Also, the shorter and more concise you can be with your questions, the better it is for all of us. Occasionally, some folks will type in several paragraphs, and honestly, it's just awkward for me to sit here and try to read through it as quickly as I can while everyone else is waiting patiently. So the shorter, the better. So let's say you have something that's unusually complex or very specific to your situation. We'll do one of two things. We'll either wait until the end of the presentation and I'll come back to it, and we'll deal with it then for the good of the body if people want to hang out and listen to our conversation, or we'll take the conversation offline, meaning that you can contact the office directly. The phone number and the URL for our website's on the screen right now. Reach out to us, please. Our administrative staff can handle a lot of the questions that come in. And if it seems to be above their pay grade, well, they'll escalate it up to an attorney or one of our senior staff. And there's a very good chance that someone will get back to you within 24 hours, because we realize that if you're calling with a question like this, you might be dealing with tight deadlines. So we try and make that turnaround fairly quick. Okay, so I think that takes care of all the preliminaries. Let's go ahead and dive into the presentation itself. And there we go. I want to start with a fundamental statement. And I was thinking this morning that, someone wrote this into the law over 70 years ago, and yet it still carries weight today, is very relevant. But this is kind of in what I call the preamble to the Sunshine Act, or like I said, more commonly known as the Open Meetings Law. But the reason this law is important is because it emphasizes the right of the public to be present at all meetings of agencies and to witness the deliberation, policy formulation, and so forth, because it is really cuts to the quick of the democratic process. And we don't want secrecy in how our government conducts its business to undermine that democratic process and the faith that the public has in government. All too often, and it just seems to be the American way, we question authority. But in recent months, I've had the opportunity to travel abroad, And, public meetings where a citizen can stand up and confront their public officials is uniquely American. And, I realize I'm on my soapbox here, but this cuts to the quick of why democracy is so special. And it's laws like this that govern how we conduct these, pardon me, how we conduct these public meetings that are so important to our form of government. So I like to say that when we look at the Sunshine Act and the importance of how we conduct public meetings in Pennsylvania, that it's a stool with three legs. And someone will call into the office occasionally and they'll ask, well, is what my local government did, is it illegal? And we tend to look at three things. First is, did they provide advance notice of the meeting? And did they provide instructions on how you can attend? And that's even more important now with the plethora of online meetings that we have. Then, was there an opportunity to observe the deliberations? And when we talk about the use of the term deliberations, that's discussion that will lead to a decision. So, were you able to listen to your public officials explain why they arrived at the decisions that they did? And this isn't always clear. And sometimes, this provision is misused. Um, and then finally, was the public provided the opportunity to comment on that deliberation before the decisions were actually made? Meaning, was I given the opportunity to stand up in front of my public officials and express my opinion, my observations as to the matter at hand? Okay. If any of these three elements are missing, then it could be problematic for the government agency that was conducting the public meeting. But these are the three basics, and I'll be covering these in greater detail as we proceed through the presentation. So let's move on and cover a couple preliminaries as well with who is covered. And when I'm telling people, or people call in or they send us an email and they don't understand a law, whether it be, the Sunshine Act or the Right to Know law or occasionally some other law. Uh, I ask them, well, have you actually read it? And if they have, I then ask, well, have you looked at the definition section? A lot of times when you're trying to understand a law, how it works, what its intent is, and so forth, uh, I always go to the definition section, because if you find language that might be vague or language that appears to be in conflict with another section of the law or maybe another law altogether, oftentimes you can find the answer by looking at the definition section. So what I'm going through now is actually gleaned from the Act and the definition section of the Sunshine Act. So what the Act says is that it applies to any state or local government body and all committees. And note we have committees italicized there. These bodies must perform an essential government function. Okay, well, what is that? And this can be somewhat subjective, but I like to use an example of the girls' softball team. Okay, let's say that you are a township and the local girls' softball team has won the state championship. Quite an accomplishment and something that the township feels it should celebrate. So they appoint an ad hoc committee to arrange a celebration. Maybe there's a parade, maybe there's a gathering at the township park, and the team's efforts and accomplishments are recognized. Well, I think, hopefully without insulting anybody, we could argue that having such a celebration would not be considered an essential government function. There's nothing in legislation or by ordinance that requires a government entity to have such a celebration of recognition. Okay, but let's turn the tables a little bit. Let's say that this same township has appointed a standing committee that periodically reviews all local ordinances to ensure that they are consistent with state and federal statutes, that the language is understandable, that they are still relevant, giving changing conditions and so forth. There, I think we could argue that it is an essential government function. So, looking at this language in the Sunshine Act, we could say that the first committee, the special committee appointed to organize a celebration, would not be subject to opening their meetings for public observation and participation, whereas the second one very well might be. And again, there's always exceptions and exceptions to the exceptions, but just for purposes of example, I think you can see the difference between one committee's work being essential where the other is not. Then we move up to the next standard, which I think is probably the most important one taken out of the definition section itself, and that is exercises authority to take official action. Okay, what is official action? Well, sure enough, if you look at the definitions, there's a definition for official action. And within that, it includes the term making recommendations, which takes us back to this question of whether or not committees are covered by the Sunshine Act. So we have to answer the question, does the committee have the authority to take official action? And that official action could be in the form of making recommendations back to the elected board. You see how this circle works here. Okay, so you're thinking, well, what committee wouldn't make recommendations back to a board? And interestingly, you'll find them out there. Sadly, occasionally issues will come up where they're divisive, but they're not critical. And sometimes the best solution that public officials will take is they'll appoint a committee, and hopefully that committee will never be heard from again. Okay, they kind of go off on their own and never report back to the elected board. Okay, it dies a slow death in committee. Then you find that there are some committees that are self-perpetuating. And by that, I'll use the example of there are some public libraries that are completely independent, okay? And if there is a vacancy on the library board, the board itself, the library board, is responsible for appointing a replacement. And they never really report or make recommendations back to the elected officials because of the lack of a nexus between the governance and operation of the public library and the local municipality. Okay, there could very well be funding provided, but there's no control over the governance by the elected officials over the library board. So it functions as a committee, but it doesn't report back to the elected officials at all. In that instance, given the lack of other criteria established by the Pennsylvania Public Library Code, that the meetings of that public library board would not be subject to the Sunshine Act. Another example might be where the committee is appointed in an ad hoc status, but they're tasked with simply gathering information and not providing any recommendation back to the elected officials. An issue comes up, we need more information about this. We need to be educated. So we're going to appoint a committee. Maybe it's made up of staff members, maybe one or two elected officials, and we want you to go out and gather information on this topic so that you can come back, report back to us the information. We don't want your recommendation. We'll figure it out. but we want the information so that we can make an informed decision when it comes time to deliberate and ultimately vote on this matter. So the gatherings of the committee that's tasked with gathering information, again, would not be subject to the Sunshine Act because they're not conducting official action per the definition of official action in the definition section of the Sunshine Act. Okay, so hopefully that sheds some light on the whole issue of committees. But this is just looking at the language in the law itself. Let's take a look at case law related to the Sunshine Act. And I'll begin by admittedly saying that, number one, there's not a lot of case law uh, out there with the Sunshine Act. There was, kind of a blip on the screen during the pandemic with litigation related to the Sunshine Act. That's kind of settled down now, although, I'm going to say that there's probably more um, litigation now in the pipeline than there was before the pandemic. And, that just might be, brought on because of conditions related to the pandemic, or it just might be that there's a trend for the public to, a greater emphasis on holding their public officials accountable. But we're looking at whether or not committees are covered. The seminal case that typically is referred to is called Ristow versus Casey. And this would have been Governor Robert Casey back several decades ago. But the issue was whether or not an ad hoc committee appointed by the governor their gatherings would have been subject to the Sunshine Act. Interestingly, the decision was that in this particular instance that they were not, but the case itself provided some good language that's been used as guidance ever since. And it kind of dives down into the language of the Sunshine Act with providing additional explanation. So let's take a look at just what Ristow, in essence, says. And there's a couple questions here that have to be answered progressively. So the first thing we need to answer is, does the committee have decision-making authority? And this kind of goes back to the example that I used of the committees that, really don't. Some are appointed, to talk about an issue, but not really make any decisions, or some are appointed to simply gather information. Then we take a look at, are the members appointed by the board, and are they authorized to act on its behalf? And, I would refer you to the example that I used with the public libraries, where the library board is self-perpetuating, that when there's a vacancy, the elected officials don't appoint a person to the vacancy, but rather the board itself has to go out and find somebody willing to serve, usually in a volunteer capacity. And then the one that I consider the most important are the recommendations pursuant to statute, ordinance, or regulatory authority whereby the making or enactment of laws, policies, or regulation is the end result. And here I would go back to the girls softball team example. Okay. All of the qualifications, all of the standards have been met until you get to this one, because you're not going to find anything in statute or ordinances that requires a government agency to have any sort of celebration or recognition ceremony for the girls softball team winning the state championship. Okay, it's not based on any law or regulatory authority. Okay, but yet you can find a lot of committees where their mission, their task, can be rooted back to some sort of statutory authority. Okay, in those instances where you can create that nexus between what it is the committee is responsible for and a statute, then you could more than likely successfully argue that their gatherings would be considered public meetings and should be open to public access through the Sunshine Act. Now, the question comes up, going back to the second standard, about what about the members? Okay, because there's some confusion over this. Many people think that you have to have a quorum of elected officials on the committee in order for it to be open to the public. That is not accurate. You can have a committee with no elected officials, and it is still subject to the Sunshine Act because of these other standards. Okay. Otherwise, what you could do is, if you followed this misunderstood standard, you could have just um, enough enough elected officials being part of a committee without ever having a quorum, and thus close all your committee hearings to the public and not have them available. Okay, and that obviously that wouldn't work out too well. Um, okay, so hopefully I've provided enough clarity for you to move forward here if you have any questions. But if you're still unsure, our advice is lean towards transparency. Now, number one, I'm with the Office of Open Records, and we are, kind of the state transparency office. So of course I'm going to say that. But if you're joining us today as an elected official or, perhaps a staff member reporting to elected officials, there's a practical aspect to this advice as well. Opening up your meeting to the public may be inconvenient, okay, because you have to go through the posting process. There could be delays. They're going to be there. They're going to have the opportunity to comment. And yeah, maybe it would just be a lot easier to have a closed meeting where you could get right to the business and solve whatever problem you have. But let's say that you do close the meeting and the result is a member of the public filing a complaint against you and your government entity. At that point, you very well may have to pass what I call the straight face test, where essentially you have to stand in front of a judge and explain with a straight face why you didn't open your meeting to the public per what the Sunshine Act says. Now, if you feel comfortable that you can justify that, then, that's your decision. But if there's any question and the judge rules against you, the sanctions could be far more inconvenient than having an open meeting. So my suggestion is just looking at this from a practical perspective, open your meetings to public scrutiny if there's any doubt as to whether they should be subject to the Sunshine Act or not. Okay, moving forward, let's get a little more specific and answer the question, is it a meeting? Okay, seems very basic, but oftentimes there are questions as to whether a gathering of public officials would be considered a public meeting or not. Someone calls into the office, say, hey, I saw my township supervisors down at the restaurant the other morning having breakfast. Isn't that illegal? Well, probably not. Okay. There's nothing preventing a quorum of elected officials from gathering as long as they're not deliberating, which is discussions about township business or, government business that could lead to a decision. Okay. Again, deliberation, definition, any discussion that could lead to a decision. And then is there decision making? Well, decision making is a vote. Okay. So as long as they're not talking about um, uh, government business that is, germane to their particular jurisdiction, and as long as they're not making decisions, it's okay. They can get together and talk about the weather. They can get together and talk about their families, or they can talk about the girls' softball team. Okay, that's fine. It's okay, um, as long as they're not deliberating or making decisions. Okay, now what about members phoning in, or dialing in or participating online, via Skype or Teams or, whatever platform that your local government uses. All right, let me get into this. Um, unless you are a first-class township or a borough, it is okay for a government official to participate in a public meeting in order to make a quorum, as long as the communication is firsthand. Okay, so if you are using Skype or maybe even just a cell phone, the person dialing in has to be able to hear everybody at the meeting, and everybody at the meeting has to be able to hear the person dialing in. Meaning you can't have an intermediary sitting there at the table with a cell phone up to his ear, relaying back and forth what the person dialing in is saying or what they should be hearing. Okay, it has to be on speakerphone at the very least. Now, if you are a borough or first-class township, you have to have a quorum physically present at the meeting, and then anyone beyond the quorum can then dial in or use an online program. All right, but a quorum must be physically present if you are a borough or a first-class township. Those conditions are included in the state codes for boroughs and first-class townships. So even though it's not included in the Sunshine Act, you would defer to those acts that has specific language on this. Okay, and then, like I said, we get into deliberation, decision making, and then a final word on beware of email meetings. This usually occurs when you've got several new members being seated. They've managed to get elected. You've got a new board being formed and, maybe a new chairperson. That chairperson, usually what I find is they come from a business background where everything is conducted by email, or, most business. They don't like meetings. They like to take care of business by email because it's easy, okay, and it's efficient, all right? So they come in with the mindset, well, we can just solve this problem with a couple of email conversations, right? Unfortunately, those conversations, even if they're one-on-one, but ultimately distributed to a quorum of the elected officials, where you have de facto deliberation, that could get you into trouble, because deliberation on matters of policy must occur in the public eye. They must occur in a public meeting. So be careful with email deliberations. Now, I need to distinguish, though, between policy level decisions and administrative level decisions, because administrative level decisions, you can use email among elected officials. And the example, real quick here, I'll just pull one out of the air. At last month's public meeting, the board voted to purchase a new snowplow. Okay. And the vote, like I said, the vote was successful. Okay. But now, after the fact, after the vote has already been recorded and taken place in a public setting, we have to make some decisions here on what's available. What horsepower do we want this truck to have? Is there a specific type of plow itself that we're looking for? How many axles do we want? What's the gross vehicle weight? Are there any special features that this snowplow needs? Do we want the township seal on the side of the truck? Customization stuff. Okay, the decision to purchase the plow was the policy, okay, and that took place in a public setting. Now all the finer details on, like, what color is this truck going to be, that kind of stuff, that is all administrative in nature. And if you've decided, well, we want the board to decide on all these details, you can use email, and you can have meetings outside of the public eye to deal with the administrative level of decision making. Just be careful, okay? Don't try to outthink the Sunshine Act by saying that, okay, well, we're just going to say this is administrative, when in fact it is policy, okay? Usually there's a common sense test that you can use or, that you should be using. And it doesn't make sense that this is administrative as opposed to policy. And again, beware of that straight face test that I warn you about, because if someone files a complaint, you're the one that has to stand up in front of the judge and explain what's the difference between administrative and policy when it comes to why you met and didn't allow the public to participate in the decision-making process. Okay? Probably more than I should have said on the whole email subject, but we see this happen periodically, and we just want to put that warning out to you. Okay, what is not a meeting? Well, the one I just talked to ad nauseum about, administrative action versus agency business. Then we run into work sessions, conferences, and retreats. Okay, now these are gatherings of elected officials, but there's no deliberation or decision making taking place. So it's okay for them to meet. And I think when we mention work sessions, I like to use school boards as an example, okay? Because most school boards will have like a monthly business meeting where, yeah, they have public discussion and they have votes, but then they'll also have a monthly work session. At these work sessions, the communication is pretty much one way, okay? You have a quorum of the board seated there. And then you have like the superintendent, assistant superintendents, assistants to the assistants of the superintendents, principals, vice principals, and the like, all making presentations to the board on matters that are either coming up for a vote, or the board has decided they want to monitor this, or they just need educated on for their own good so that they can make informed decisions when it does come time to vote. So the presentations are being made by staff. Individual board members can then ask staff for clarification, and they can have a conversation with staff. But the board members themselves, as a group, cannot discuss the merits of what's being presented, because again, that falls back to the definition of deliberation. Deliberation must take place in a public setting, and these work sessions may or may not be open to the public. If they're not, then certainly no deliberation. Occasionally, you'll run into cases where all the conditions of the Sunshine Act have been met, but the board still calls it a work session. And occasionally, they will vote during a work session. I would caution you against that practice, because by calling it a work session and not a public meeting or a business meeting, you are creating the impression to the public that no decision making will take place. Okay, and that's kind of the smoke and mirrors kind of thing where people are attempting to outthink the Sunshine Act, and you're going to get yourself in trouble. I've also seen in the last couple of years a thing called committees of the whole, where you've got the entire board meeting, but instead of calling it a board meeting, they're calling it a committee meeting. And deliberation takes place, but they don't allow the public to attend. Again, this is kind of semantics and smoke and mirrors, where I think, if someone files a complaint against one of these committee of the whole gatherings, you're going to find yourself getting into some trouble. And don't do that. Okay. Do not try to outthink the Sunshine Act, because invariably, and history has proven this, you're going to find yourselves getting on the opposite side of the law. And I don't know how many of you have attended court hearings with a common pleas judge, but you catch them on a bad day, you're going to be in trouble. Okay, so be careful about this. Follow the law, follow the intent of the law, and you'll be okay. Okay, but the two big things when it's not a meeting is that there's no deliberation, there's no discussion that would lead to a decision, and there's no decision making taking place. There are no votes. Okay, that would not be considered a meeting. All right, so we come to the first leg of this three-legged stool, public notice. Well, usually what happens, and this is by code, at the beginning of the calendar year, usually by the first Tuesday, you have to have an organization meeting. So the board will meet, and prior to that board meeting, there needs to be a legal notice in a paid newspaper of general circulation as to the date of the meeting. And that needs to be published at least 3 days prior to the organizational meeting. And usually what happens is that that legal notice, to save money and sometimes simply because it's convenient to do so, will also include all of the dates for the remaining regular meetings throughout the calendar year. So that if your meeting, if your meeting date is the first Tuesday of every month, you list those dates in your legal notice, and that's fine. Okay, that's usually how it works out. Now, let's say that you have your organizational meeting and there's a conflict. Someone else has another meeting that night and it's just not going to work out for them to attend. So the board decides, okay, well, now we're going to meet on the second Tuesday of the month. If that happens, then you have to publish a second legal notice amending the meeting dates for the remainder of the calendar year. Uh, Legal notice in a paid newspaper of general circulation. Okay, so articles are what are known as puff pieces that might happen to say the board meets the first Tuesday of every month. That's not good enough. It has to be a legal notice. Websites, while you can use social media to advertise your meeting dates, okay, that does not satisfy the language in the Sunshine Act. Okay, you must have that legal notice. And, I'm the first to acknowledge that there are structural changes occurring in the news media industry right now that's making it more difficult to meet this standard. But until the law is changed, and if this is a concern for you, reach out to your state rep or your state senator and let them know of your concerns. But until the law is actually changed, you need to follow through with these legal notices. So, it used to be Harrisburg's a good example. Harrisburg used to have twice daily newspaper. Now I think it's down to 3 days a week, and one of those days is a Sunday. So it's becoming more and more difficult to publish these legal notices. And you not only have the 72 hours to worry about, you've got the publishing schedule to worry about. So if you miss your 72-hour deadline, yeah, it could be problematic. But you do the best you can for now. And those sales circulars, the free ones that show up in your mailbox 2 or 3 times a week, they don't count because it needs to be a paid newspaper of general circulation for your jurisdiction. Okay, and then you must also post the meeting schedule at the meeting site. Okay, that must be available as well. All right, special meetings. Okay, this is where an issue comes up that can't wait until the next monthly regular meeting or whatever your meeting schedule is. So you've got to have a special meeting prior to that. The Sunshine Act accommodates this. It allows you to have special meetings and all of the conditions, the same conditions must be met, except now the advance notice goes down to 24 hours. Okay, but again, you need to be aware of the publishing schedule for the paid newspaper. But as long as it gets published 24 hours prior to the special meeting, you're good. All right, now what about emergency meetings? Let's go back to the snowplow. Let's say that our little borough only has one snowplow. Okay, and that's, for years, that's been enough. But it's on its last legs. It just recently broke down. The forecast is calling for a nor'easter to come up the coast and dump 2 feet of snow. My gosh, we need a new snowplow and we need to go out and buy it now because this is an emergency. Okay, you're allowed to have an emergency meeting where there is no prior notice, where the board can get together, vote to purchase the new snowplow, and it so happens that, down the road, there's one sitting on the lot, so we can get it here quick. All right, you can do that. Just again, don't create your own emergencies that aren't truly of an emergency nature. Okay, and we've seen that done in the past. Again, my advice is don't attempt to outthink the law because ultimately you will get caught, and the sanctions can be significant. All right. And then if you have to cancel a meeting, whether it be regular, special, or whatever, there's no legal requirement for public notice related to cancellations. But my advice is to use your social media to get the word out there that, we're canceling tonight's meeting because we couldn't get a quorum because, somebody's sick or they're out of town or whatever. Okay. Nothing is more frustrating to someone who is going out of their way to attend a scheduled public meeting. They show up at the township building or borough hall and all the lights are out and it's crickets. And, then the next day they make some phone calls. It's like, oh, well, we decided to cancel because we couldn't get a quorum or something like that. Okay, whatever you can do to get the word out to the public that you're canceling a meeting, it could save you some heartache in the long run, bad feelings, et cetera, et cetera. Okay. Do what you can there using your social media resources. Okay. I want to talk about agendas. I used to say this is a new part of the law. Let's just say it by now, it is newer. Okay. It was passed a couple years ago, and it was in response to the public complaining that issues were coming up before public officials that they were voting on that we had no idea it was going to happen. So we didn't attend the meetings and they snuck this through. And, we wouldn't have approved of this had we been at the meeting, or we would have, why weren't we given a chance to public comment on this? So now it's required of all agencies to post an agenda at least 24 hours prior to the actual meeting. And that agenda should include all matters that the board intends to deliberate or take official action on. Now, oftentimes we get the question, well, how detailed does our agenda need to be? Okay, and this isn't part of the Sunshine Act per se, but let me think here for a second. There was I refer to what's called the Reading Eagle case, and this involves a different part of the Sunshine Act, but it had to do with giving reasons for an executive session. Okay, in that case, while it dealt only with executive sessions, I think it provides some useful language and a standard that you can turn around and apply it to how detailed your agendas need to be. Now, I need to emphasize that this is not case law specifically related to agendas. This is simply George applying the logic that was used for one part of the Sunshine Act to a different part of the Sunshine Act. Okay, there's no legal standard here. It's simply me trying to make sense of of a situation that isn't specifically addressed by the act. How detailed should our agendas be? Well, you go to the Reading Eagle case and flesh through the language, and it says you need to provide enough information so that the public is satisfied you are not misusing the law. So I think you can kind of use that common sense standard with how detailed your agendas need to be by providing enough information so that a typical person can glean from the explanation as to what it is specifically that the board intends to discuss. Okay, if you simply put down, we're going to discuss ordinance XYZ 123 without any explanation as to what that ordinance is to someone who, is not intimately familiar with your government agency, that's problematic. So you provide a bit of an explanation. Maybe it takes a paragraph, okay? But at least then someone looking at your agenda has a reasonable idea as to what it is the board is going to be talking about, okay? Look at this from the public's perspective, and I'll say an uneducated public. Okay, so you use your agenda as an opportunity to educate them. Okay, we're going to be discussing a recommendation from the zoning hearing board to change the zoning on these parcels of land so that they could put up a warehouse. Okay, big issue where I live about, with the propagation of all these warehouses. Okay, and the public shows up whenever there's going to be discussion or votes on these warehouses that they're putting in. Okay, so the public now knows what to expect. You have to have the agenda for all regular and special meetings. So you would not have agendas for work sessions, conferences, and executive sessions. Okay. Now, if you have a website, you have to have the agenda posted on your website. And there are some municipalities that, while they don't have websites, they have Facebook pages. Well, then we defer to the Facebook page. You put your agenda on the Facebook page. So the agenda needs to be posted on your social media. It needs to be posted at the agency offices. It needs to be posted at the meeting sites. And you need to have copies available, copies of the agenda available at the meeting itself that can be distributed to members of the public as they come in. All right, so that's 24 hours prior to the actual meeting. Let's talk specifically about the timeline. What if we want to change the agenda? Okay, well, prior to 24 hours, it's an open book. You can change whatever you have to on the agenda more than 24 hours prior. Okay, now 24 hours comes up. What about this window between the 24 hours and when the meeting is called to order? Well, you can make changes to the agenda, but only for items that would be termed as de minimis, where there is no expenditure of funds and you're not going to enter into any contracts. Okay. If the board is going to discuss matters of that nature, it's okay to change the agenda. All right. That's the standard during this 24-hour window. Okay, question has popped up. Can you add change denial to an exiting contract agreement to the agenda or have to wait for the next meeting? Okay, Ruth Ann, you're about a paragraph ahead of me here. And we're going to get to it right now. Okay, so we've passed the 24-hour window. Now the meeting has been called to order. And let's say throughout the course of the meeting, something comes up that the board decides we need to talk about this now, but it's not on the agenda. Okay, like the contract that you're talking about, Ruth Ann. Okay, and maybe it's exiting the contract, but we need to discuss this at this meeting. We need to deliberate. So what the board can do is a two-step process. First, they vote to amend the agenda to include the new item. And they have to do that by a public vote. And they need to announce to the public at the meeting why they are amending the agenda. And it's so we can discuss this contract. So then they take the vote on amending the agenda and it passes. Okay, well, because they voted, it becomes a matter of public record because all votes need to be recorded in the minutes. Now they can move on to deliberate about the issue that they amended the agenda for, the contract. And because they're deliberating, well, deliberating could lead to a vote or it could not lead to a vote. Ultimately, it depends whether there's a motion or not. But you can deliberate without having a vote, but you must deliberate in a public setting. You've amended your agenda, so now you deliberate. If you do vote, that's also a matter of public record, like it would be if it were on the agenda in the first place. Okay, so the two steps are you amend the agenda and then you move on to the new agenda item. Okay, and then you'll be okay. So Ruth Ann, that's how I would handle that specific issue. Rather than take the chance on amending the agenda during the 24-hour period, that window, I would just wait until you've called the meeting to order and then go ahead and deal with it in the public setting. okay? But that's up to you. I mean, the law does not go into great detail on the points of order in how you see that all this gets taken care of. All right. Now, if you have amended the agenda, you need to post the amended agenda within 24 hours of adjourning the meeting. And again, it's at all the places where you posted it in the first place. Now, the question has come up. Okay, so we post the amended agenda. How long must it be posted for? The law does not say. So again, this is George, not any case law and not any legal requirement in the Sunshine Act, but applying common sense, which I'm not always known for, but applying common sense. If there's a 24-hour standard for posting agendas prior to the meeting, then let's apply the 24-hour standard to posting agendas after the meeting. Okay, now, in all honesty, this is, me backpedaling a little bit here. When and if this issue ever gets litigated, a judge may agree or a judge may disagree with what George said. And you're going to stand up and say, well, George from the Office of Open Records said 24 hours. What I'm saying is purely a non-legal opinion here. All right. So I just want to, that's my caveat. Okay. This is just me saying, try it for 24 hours or longer. It's up to you. There's no language that establishes a legal requirement and there's no case law. So post it for 24 hours based on the 24-hour standard that's already been established. We'll see what happens. Okay. And we'll take it from there. Okay, public comment. Public comment, that provision of the Sunshine Act only applies to local agencies. It does not apply to state level agencies. All right, so let's look at what the law says. First offhand, commenters can be limited to residents and taxpayers, meaning that if you have someone coming in from outside your township, let's say they live in an adjoining township and there's something's going on that they're concerned about. Maybe it's, one of those warehouses and zoning issues. They want to comment. Well, the board legally can say, no, okay, you're not a taxpayer, you're not a resident of the township. We don't have to allow you public comment. Now, the law says that the public has a right to comment on issues that are or may be before the board before any pertinent votes take place. That word may that's in there, it can be problematic because it kind of opens up the topic of public comment to anything that might be on this person's mind. It could be, why isn't the borough fixing the townships in front of they pay me to speak. Why isn't the borough fixing the potholes in front of my house? All right. Technically, they're allowed to comment on that because this word may, and you would go back to another law called the Statutory Construction Act. But anyway, there are ways to deal with this, and I'm going to talk about this here in a minute. But what you want to be careful of is shutting people down during public comment for any reason. There was a flurry of legal activity at the federal level a couple years back where school districts, one in particular, would cut people off during public comment if they felt the comments were not relevant to the matter at hand. Using this language of the Sunshine Act and the Constitution, people turned around and filed civil litigation in federal court saying that the school district was abrogating my rights to free speech by not allowing me to comment. and the school districts were using a fairly tight standard on what was relevant versus what was not relevant. The federal courts agreed with the public and chastised the school districts for cutting these people off, saying that, yes, you did violate their First Amendment rights. So be careful how you handle all of this. Now, boards may establish reasonable rules for public comment. Typically, what we hear about are the time standards. You've got 3 minutes, okay, or 5 minutes or whatever. Now, usually these standards are established per the rules of order for meetings, okay? There's nothing in the Sunshine Act that says you must give 3 minutes for public comment. Because it's in the rules of order, a board has a degree of flexibility with changing those rules of order. You can vote to set the rules aside. You can vote to amend the rules, okay? We've got a particularly important issue tonight, so we're going to give everybody 5 minutes instead of 3. Or, here's an example. Let's say that, I talked about, let me talk about spokespersons. Let's say there's an important issue tonight. And a group comes in, they're all wearing the same t-shirts, and they all sign up for public comment. Well, there's nothing preventing the chairperson from approaching that group and saying, look, we've only got so much time tonight, and to prevent a lot of repetition, would you guys be willing to appoint a spokesperson? And rather than 3 minutes, we'll give your spokesperson 10 minutes to make sure that all the points get covered. Okay, that way we won't be here all night and you guys will have your say. What do you say to that? And they agree, okay? You can do that, okay? As long as everyone feels they're getting their fair shake, you'll be okay, all right? And then getting back to this right to comment on issues that may be before the board. There is a practice that's kind of gaining steam in Pennsylvania with local governments establishing 2 comment periods. The first is specific. Okay, we've deliberated, we're getting ready to vote on this particular issue. Now we're going to allow public comment, but comment is limited to this specific issue. Okay, and we would ask that the public please conform to this. Then at the end of the night, we're going to have a general comment period where if you want to bring up the potholes in front of your house, this is the time to do it. Okay, now, again, I want to emphasize there is no legal requirement that you do this. Rather, it's what we view here at the Office of Open Records as a best practice. Was brought to our attention by a couple of municipalities. Hey, this is what we started doing. Is there any legal problem? And, we kind of say, well, there's no case law to indicate such, but they've said, well, it's really working out for us. And we've used this as an opportunity during training just to kind of spread the word, okay? Again, no legal requirement, simply a best practice. If you want to try it out, maybe it would work for you as well. Okay, let's spend some time talking about executive sessions. Executive sessions are gatherings of the board that can be held for discussing sensitive issues outside of the public eye. Executive sessions can be held before, during, or after an open meeting, or they can be announced during an open meeting for being held at a future time, again, outside of the public eye. When you announce the public meeting, you must also give the complete reason for why you are having the executive session. Okay, and we refer back to that case I referred to earlier, City of Reading versus the Reading Eagle. The practice was by Reading City Council where the chairperson would stand up and say, we're going into executive session for personnel reasons. And the Reading Eagle, which is the local newspaper, disagreed with that practice and they took them to court. And the court agreed with the paper. And essentially, what that decision says, well, look, when you're going into executive session, you are taking it on the public's trust that you're going into, you're taking your business out of the public eye, so you must provide an expansive enough reason to maintain that trust. So rather than simply saying personnel reasons, you would give an explanation. We're going into executive session so we can discuss possible sanctions against this employee or you wouldn't name the employee, but against an employee for potential violation of work rules. Okay. Disciplinary reasons. Okay. Or rather than saying legal reasons, we're going into executive sessions to discuss the status of this litigation where XYZ company has filed against us in court, and maybe even give the docket number for the case. Okay, questions popped up. Are there any requirements for advertising in an executive session? There are not. No advertising requirements for executive session. Okay, also, there's no requirement for keeping minutes of an executive session, although you can. And if you do, those minutes are exempt from public disclosure under the Pennsylvania Right to Know law. Now, you can have discussion during an executive session, and you can even poll the members for their opinions on how they're going to vote, but you cannot vote during an executive session. All votes as a result of deliberation during an executive session must take place in a public setting in order for those votes to be valid. So you would have your executive session, you would have your discussion, maybe you poll your members, well, Fred, what do you think? Alice, what do you think? But in order for the resolution of whatever was decided during the executive session to be legally binding and official, you must adjourn the executive session, reconvene the public session, and then take your vote before the public as you would any other matter. And that way it gets recorded in the minutes and it becomes official action. Okay, that's how that works. Okay, the reasons for executive session, like I said, personnel matters, hiring, firing, discipline. For personnel matters, they must relate to specific positions or specific employees, not personnel policy. So if you're going to be discussing disciplinary policy or leave policy or whatever, that's public. But if you're going to be discussing, let's say, a specific person's leave abuse, that could be discussed in executive session. Or if you're discussing filling a specific position, that can be discussed in executive session. Policy level personnel issues must be discussed in public. Discussing labor negotiations and strategy, yeah, that makes sense. Considering the purchasing, leasing, or selling of property. If you look at the act itself, it does not include the word selling, but there is an unpublished Pennsylvania Commonwealth Court decision where the court concluded that if an agency is selling property, they can discuss that in executive session as well. Consulting with counsel about litigation, that makes sense. Avoiding violating privilege or confidentiality. Okay, privilege is typically attorney-client privilege, where an attorney, a solicitor, is providing legal guidance to the board. Okay, let's say you're having a public meeting and one of the members of the board says something, suddenly the solicitor's eyes get real big and they say, we need to go into executive session right away to discuss confidentiality issues or to discuss privilege. Okay. Then you go into executive session and the solicitor says, you shouldn't be saying that in public. Okay. That is attorney-client privilege, which can be covered by executive session. Okay. Discussing university admission standards. I don't know. I wasn't around 70 years ago when they wrote this into the law, but it's there. Discussing emergency preparedness, like homeland security, things that by discussing it in public might violate public safety or compromise public safety. Okay, that you can discuss in executive session. Okay, questions popped up here. for those who attend an executive session, are the discussions private? Well, they should be. I mean, that's the intent of executive session. Now, I know the second part of your question, is there a penalty for divulging information to the public? Meaning, are you violating the privilege that's established in executive session? Nothing legal by statute for a sanction against someone, but a board can, what's the term that I want to use? They can sanction somebody. They can say that, what you did is bad and you shouldn't do it again. And ultimately, they can take steps to kind of limit what information that person has access to in the future. If they turn around and divulge anything that was said in confidence during an executive session. Okay, and usually what a board will do is say, we're going into executive session, and by the way, you're not invited. I've seen that done, but there's nothing by statute that gives them the right to otherwise sanction somebody. Okay, running over a little bit here, but we're covering some good stuff. Okay, I mentioned earlier about violations. Okay, how does this work? Well, during a public meeting, if a member of the public thinks the board is violating the Sunshine Act, the law allows them to stand up at any time and address the board and say, I think this represents a violation. The board can then say, thank you. Okay, now please have your seat. That person is not out of order. Okay. When I say sanctioning, well, yeah, we're going to talk about sanctions here. But for a board to I think this goes back to your previous question. For a board to sanction another board member, basically what you're doing is shutting them out from their ability to function as a public official. I would say that has a lot of meaning because why would you have an elected official having any authority if the rest of the board is not honoring that authority by including them in meaningful discussions? And I've seen this happen. I've seen it happen to school board members or other people who were a little fast and loose with confidential information. So yeah, I would say it does. It just, it depends on the specific circumstances and what the board is doing to sanction that individual member. Now, about real sanctions, that's what we're talking about right now with the Sunshine Act. So pay attention. Okay. So this person stands up. They say, you're violating the Sunshine Act. The board says, okay, thank you very much. Now, what if the board agrees that, yeah, we did just violate the Sunshine Act? The law allows the board to cure the violation right then and there. So it's like, yeah, we forgot to vote on this issue. So let's take the vote right now. Okay. And they go through the administrative action to take care of that vote. Okay. So they have cured the violation. But what if they disagree? Nah, that's not a violation. We're fine. Okay. The member of the public has 30 days in which to file a complaint. For a local agency, it's in the Court of Common Pleas. For a state agency, it would be the Pennsylvania Commonwealth Court. And they seek legal relief, meaning, I want declaratory relief or an injunction, whatever. Okay. Every county is kind of different in how this works. So you need to kind of get familiar. Maybe you want to get an attorney. Maybe you think you can handle it yourself. But you seek legal relief in your Court of Common Pleas for a local agency, alleging that the board violated the Sunshine Act. Most judges will conduct a hearing, okay? And this is where that straight face test comes into play, where based on the complaint, the parties get their say in front of the judge. Now, if a judge agrees that, yes, you violated the Sunshine Act, they have great leeway in what the sanction is. Okay, it could be a simple slap on the wrist where they say, yes, you violated the Sunshine Act, don't do it again. Or they could void a vote, or they could void an entire meeting. Or if it's particularly egregious, the sanction would be, I can fine you up to $1,000 per member for the first violation. And the agency cannot foot the bill. Rather, the $1,000 must come from the board member, each board member who violated the act. Okay, and it's $1,000 for the first violation, $2,000 for the second violation. Okay, so Mr. Dodson, you can see here the sanctions do have real meaning because suddenly it starts getting really expensive and the money's coming out of the board member's pocket because the agency may not pay the fines on behalf of the board members. Okay, so also, if you think that there is any criminal culpability, in addition to filing in the court, you can also approach the county district attorney and they will conduct their own investigation. They will not rule on whether or not there's been a violation of the act, but they will rule on whether any criminal activity took place related to the violation of the Sunshine Act provision. Okay? Then just some miscellaneous stuff before we call it a day here. Um, all public meetings, you have to produce meeting minutes, recording board attendance, and if there was a roll call vote, how each member voted, yay or nay. This is also, you'll find in the codes for boroughs, townships, and the like. Oftentimes there are provisions in there for the maintaining of minutes. Okay, now, recording, okay? The public can record public meetings and they don't have to let you know that they are doing it, okay? It's not a violation of the Sunshine Act. It's not a violation of the Pennsylvania wiretap law, okay? I can set my cell phone on record, stick it in my pocket, walk in and not say boo. So what I recommend is at the beginning of the meeting, the chairperson stand up and during the introductory comments, they say, by the way, this is a public meeting. There's no expectation of privacy and this meeting may very well be recorded. And many agencies are recording their public meetings. You know, they're live streaming them or they're recording them and posting them to their social media anyway. So it's good to let the public know that that's happening. And if an agency is doing that, the recordings are considered public records under the right to know law, and the minutes generated from a public meeting are considered public records under the right to know law. Clearly public, clearly accessible to the public through the right to know process, okay? All right, so we are at the end of our presentation. If you have any further questions, now's the time to get them in. Okay, if by chance we end the session and then you think of a question, like I said at the beginning, reach out to us, okay? Call the office or send us an email and we'll be happy to get back to you and get you steered in the right direction, okay? But in the meantime, I want to let you know about, okay, question has popped up, question mark. I'm not sure what that means. If you have a question, let me know. Take a look at our website. There's a wealth of resources on there. There's a page specifically for the Sunshine Act. It has an FAQ section where it answers a lot of the questions that we've talked about today. Recordings of previous training sessions are on there. Okay, the recordings have to be posted on a website or Facebook. No, Teresa, they do not. Okay, the recordings, it's really what you want to do with them. Sometimes they're recorded just so that the secretary can then generate minutes. Okay, and they don't have to be posted anywhere. No legal requirement for recordings to be posted. Okay, but if you want to, you can. And, you know, I think that's a good practice nowadays. public Zoom meeting status. Okay, yeah, great question, Mr. Dotson. Um, the recordings of Zoom meetings are considered public records, okay? And depending on the version of Zoom that you have, the recording is kept on the host's account, or if you have a higher level account, the people participating in the Zoom meeting, meaning the public, they can record locally. It all depends on, which version of Zoom you have. Same way with Skype, Teams, and the like. But if you have the recording, it's considered a public record. Fortunately, you can usually simply provide a link to the recording. Zoom will accommodate that, last time I checked. So it's fairly simple to do. But it is considered a public record as long as that record exists. Okay, so yeah, that's a good one. Okay, another one's come up. When there is a discussion during a public meeting where it is mentioned by the supervisors that there has been communication back and forth regarding a specific topic, one submits a right to know request for that communication. They do not know the specifics of what to ask for. And then the right to know for lack of specificity. How does one know what to ask for? Okay, you're actually talking about a right to know question, not Sunshine Act. But let's go ahead and deal with it because, it involves public discussion. It is problematic sometimes when, okay, Tracy Jones is saying, so the recordings must be saved. Okay, let me deal with Tracy's question since it's kind of a continuation. Then I'm going to come back to the other one. There is no requirement that the recordings must be saved, but if you do save them, they are a public record. Now, what does the law say? Probably the best law to refer to is the Pennsylvania Municipal Records Act. It applies to local municipalities, except school boards, okay? And it says that you maintain a recording for as long as there is an administrative need for doing so, or 2 years, whichever is shortest. So let's say you maintain the recording to generate the public or to generate your meeting minutes. In that case, you save the recording until the next public meeting where the board approves the minutes for the prior meeting. At that point, you can erase the recording unless you have an administrative need to keep it longer. Then the minimum is 2 years per the Pennsylvania Municipal Records Act. Okay, and you can find that online on the Museum Commission Bureau of Archives and History's website, another very good resource. Okay, Tracy, hopefully I answered that, what you were looking for. Now, let's go back to, and I need to come over to the other screen where the comments are and scroll back to make sure I have all this. It's not scrolling. There we go. Okay, Miss O'Rourke's question here. Okay, so it can be frustrating. Sometimes a board will come in and they'll vote on something without any deliberation. It's like, how do you guys know how to vote when you're not even talking about this? Which leads me to suspect that there was some discussion or some exchange of information that took place prior to the board taking a vote for a potential violation of the Sunshine Act, because that deliberation should have taken place in the public eye, okay? Seems kind of fishy. All right, so I'm going to file a right to know request. And how do I know what to ask for? I think that's what Tina's getting at here. Well, first off, Ann, if it was a verbal communication, there's not going to be any record of that discussion. So you're going to come up, empty-handed. But what if there was an exchange of email? Okay, so I can ask in my right to know request, I would ask for, any and all written communication, including emails, text messages, and the like, related to discussions that took place leading to this particular issue that was referred to in the public meeting. Okay, you do want to try to get as specific as possible, but sometimes it can be very subjective. But when it comes to specificity, you want to know what is the subject. You can't just ask for any and all communication between the supervisors, okay? Because that's not specific enough. But if I say any and all communication about, let's say the Elm Street project, that would be specific. Then I need to identify a time frame, and usually it's that took place prior to the public meeting or prior to the vote that occurred. And then you need to identify the parties. And here, because that communication took place among the board members, because that's your concern, because they voted on something without deliberation, you would say any and all communication related to the Elm Street project that took place between the elected members of the board on this particular subject during this particular time frame. Then you would be specific enough. We're talking about the right to know law here, not the Sunshine Act. So we're kind of getting off topic, but yet they are related. It's a very good question. And there is a lot of case law related to specificity with the right to know law. Go to this great website that that's on the screen right now. Go to the docket search under appeals and just put in the word specificity. And my gosh, dozens of cases will come up that will educate you on the legal aspects of specificity related to the right to know law. Tina, that is my long-winded response to your question, but it's probably the best response you're going to get from me today. Hopefully that kind of gets you pointed in the right direction. Okay, I don't see any other questions that have popped up. Let me scroll down. And we're good. Yeah. Okay. So I want to thank you for your participation today. We had a lot of people. Oh my gosh, Isaac. Okay, he's hitting me with a big one here at the end. Can Zoom meetings, meaning can online platforms replace public physical discourse since the pandemic? Our response, our official position here at the Office of Open Records is no. You cannot have online meetings that would otherwise be public without having a physical presence. During the pandemic, there was an emergency. Okay, well, let me go into the explanation here just to back this up, and then I got to wrap this up because I've got another meeting coming up. Okay, during the pandemic, there was an emergency declaration that said you could have, our office interpreted it to mean, and so did the legislature, following it up with additional legislation, that you could have online meetings. When that emergency declaration ceased, when it expired, all of the conditions that allowed for online meetings also expired. So you can have a public meeting. You must have a physical component to it. That's based on language in the Sunshine Act. It's also based on language that isn't included in the Sunshine Act, what the Act doesn't say. Plus, we've had hearings since the pandemic with the legislature where members of the legislature made it abundantly clear. Our intent is that there be face-to-face interaction between the public and their public officials. Okay, they couldn't have said it more clearly. Now, you can still have an online component, what we call a hybrid meeting, meaning we're going to stream our public meetings and we can also allow public comment online. But you still must have a physical presence for the public to attend and have face-to-face interaction with their public officials, okay? There are some people that disagree with that, okay, outside of state government, but until it's litigated, that is our official position on this whole issue. Isaac, awesome question. I'm glad I got a chance to editorialize on that a little bit. Okay, folks, I got to call an end to this because I have to head out to another meeting. But again, thank you for your participation. We'll be back again in 2 weeks with our next Office of Open Records webinar. And hopefully we'll see you then. Okay. Take care. Stay safe. Bye bye.